One of the key pillars of the presidential petition, access to the IEBC servers and the final orders were in, albeit limited to read and copy only access. On the table were 3 of 6 specific orders sought by Raila Odinga and his running mate Kalonzo Musyoka in the petition. 1, a specific order for scrutiny of the rejected and spoilt votes. Odinga arguing that a total of 395,510 votes were unlawfully deducted from him and given to Kenyatta. 2, an order for scrutiny and audit of all the returns of the presidential election, including but not limited to Forms 34A, B and Cs. 3, an order for scrutiny and audit of the system and technology used by the IEBC in the presidential election, including but not limited to the KIMS kits, the server or servers, the website or the portal. In the court's view, the orders sought were as such in 3 categories. 1, access to information relating to the hardware and software used in the conduct of the presidential election, and particularly in transmission of results. 2, access to and scrutiny of certified copies of Forms 34As, Bs and Cs. And 3, leave to file further affidavits. As such, the judges ordered that limited and supervised access be granted to 19 of the issues Odinga had raised. Among them, number of servers in the exclusive possession of IEBC, firewalls without disclosure of the software version, password policy, password matrix, system user types and levels of access, login trail of users and equipment into the IEBC servers, login trail of users into the KIMS system, and certified photocopies of original Forms 34As, Bs and Cs, as well as scanned copies of the same. As the Supreme Court pronounced itself on the matter, it was clear in the mode this would be done. An ICT officer designated by the court from among its ICT staff and 2 independent IT experts shall supervise access to the technology.
The parties to the petition are entitled to have a maximum of 2 agents or experts in each of the above exercises. The agents should at all times comply with the directions of the registrar and the ICT officer to ensure expeditious conclusion of the above exercise.
The court also ordering that means to assist in distinguishing the fake forms from the genuine ones be provided.
The registrar of this court, assisted by a number of judicial officers and staff, as she may determine, shall supervise access to the certified copies of original Forms 34A and Forms 34B.
The Commission has absolutely nothing to hide. And our concerns relating to the integrity and the security have been addressed.
It would appear that simultaneous processes will be going on. So our only request is a copy of the ruling.
Yes.
As we engage here, other persons will be engaging elsewhere.
I fully concur with the remarks of my learned senior, Mr. Paul Mwite.
The court would, however, turn down their prayers to have direct and unfettered access to relevant persons and systems at Saffron in order for the forensic information technology experts to fully understand the KIMS system. The judges arguing that was impractical and difficult to grant, as Saffron was based in France and such would unnecessarily delay the hearing and determination of the petition. While the 7-judge bench would grant limited access to information on password policy and matrix, it would take note importance to ensure that there is absolute confidentiality of passwords and usernames, locations of servers, identity of password holders, IP addresses and software running applications, essentially curtailing the access sought by NASA on grounds that there was the risk of compromising the integrity and security of the kits would render their future use compromised. A report is expected to be filed by the registrar by 5 p.m. Tuesday. Jackie Maribe, Monday Special.
What is the issue?